Welcome. My name is Ross Baer. I am a senior attorney at the Legal Aid Society of Palm Beach County. I have practiced in the area of family law for the past 30 years. I want to talk with you about child support in the state of Florida. Child support is provided for in Florida Statute 6130. There are some common misperceptions about child support that I would like to clear up for you today. Child support is a right that belongs to the child. It is not an obligation imposed by one parent on another. Child support as a general rule under Florida law ends at the child's 18th birthday. It does not continue through college. Child support can extend past the child's 18th birthday under two circumstances. First, the child turns 18 and is still in high school and will graduate before their 19th birthday. Second, the child turns 18 and has a physical or mental disability that began prior to the age of majority. Child support cannot be waived by the parents. One parent cannot give up timesharing in order to avoid paying child support. Child support can be obtained either in a dissolution of marriage action, an action for paternity, or a petition for support during the marriage. Child support is based upon the state of Florida child support guidelines. The guidelines determine the amount of support that needs to be paid by both parents based upon their respective net monthly incomes and the number of children the parties have together. Child support is determined using two different methods. The first method is the most traditional and has been in existence since long before I started practicing law. The court takes into account the parties' net monthly income and the number of children the parties have together. In the second method, the court takes into account a separate factor, which is the amount of time the child spends with each parent. In the second method, if the child spends more than 20% of their overnights with the other parent, child support has a completely separate calculation, which will result in substantially less money for the parent that has the child the majority of the time. It is not uncommon, unfortunately, that parents fight over how many overnights are spent with the child so that they can reduce their child support. Other factors taken into account when determining child support are daycare and aftercare expenses and also health insurance for the minor child. Another consideration is the existence of a prior child support order. In other words, if you have a child with a person who has other children and that person is actually paying support for the other children, your child support is going to be affected, or more generally, it's going to be lowered. Child support can also be awarded retroactively. Previously, a parent can ask for retroactive child support going back to birth. As of July 1st, 1998, Florida amended its laws regarding retroactive child support and provided that a child could only receive retro support going back 24 months from the filing of the lawsuit. So if you sue somebody for paternity and the child is 12 years old and they've never given you a penny, you're only going to go back 24 months from the time you actually filed the lawsuit. You can no longer go back to the birth of the child. Child support can be obtained through the assistance of a private attorney during a divorce or paternity case or through the assistance of the Florida Department of Revenue. The Florida Department of Revenue is legally obligated to help you establish child support. They can not only help you establish child support, but they can also help you enforce an existing child support order. Enforcing an existing child support order is typically done through the use of civil contempt of court. Civil contempt does not have the goal of putting someone in jail, but rather of compelling people to do something that they otherwise have the ability to do. The key to civil contempt is that the person found in contempt of court holds the key to their own jail cell. An example would be a reporter who is told to turn over their source for a story. If they refuse, they're held in civil contempt. They can get out of jail any time just by disclosing the name. In other words, they hold the key to their own cell. A person being held in civil contempt does not guarantee that you will recover all the child support that is owed to you. It is a very repetitive and frustrating process. Child support in Florida is a complicated topic. It is strongly recommended that you consult with an attorney.